Duties and liabilities of the trustees. We have studied the duties of the trustees. Today we are going to discuss the liabilities of the trustees. Before we go into the topic of liabilities of the trustees, we will review what we have studied in relation to the duties of the trustees. Sections 6A and 11 to 22 of the Trusts Ordinance speak of duties of the trustees. Just we will summarize what is the sections and deal with what. In terms of section 6A, trustee shall forward information relating to trust to the Registrar General of Lands. In terms of section 11, trustee shall fulfill the purpose of the trust and also to obey the directions of the author of the trust. In terms of section 12, the trustee shall acquaint himself of the state of trust property. In terms of section 13, the trustee shall protect the trust property. In terms of section 14, the trustee shall not set up title adverse to the beneficiary. In terms of section 15, that's very important section. As I told you, that's the backbone of the duties. In terms of that section 15 of Trust Ordinance, the trustee shall deal with the trust property as carefully as a man of ordinary prudence. In terms of section 16, the trustee shall not convert the trust property if perishable nature. The trustee shall convert the trust property if such trust property is perishable nature. In terms of section 17, the trustee shall be impartial towards beneficiaries. In terms of section 18, the trustee shall prevent the waste. In terms of section 19, the trustee shall keep clear and accurate accounts and furnish correct information of the state of trust property. Section 19A, inserted by Amendment Act number 6 of 2018, in terms of section 19A, the trustee shall keep records of all information relating to trustees, author of the trust, beneficiaries, and any person engages in the execution of trusts. 19B, also inserted by that amendment, in terms of section 19B, trustee shall provide updated information to the relevant authority. Then in terms of section 20, that's very important section, trustee shall invest the trust money which is not required for immediate use in a security or bond or share specified therein. In terms of section 21, trustee may deposit the trust money which is not required for immediate use in government savings bank or the national savings bank. Section 2, finally we have seen, trust in the case of trust for sale shall sell that property within the reasonable period. These are the duties that we have seen, and the relevant cases also we have seen. Today, in this lecture, we will see the liabilities of the trustees. Section 23 lays down the liabilities of the trustees for the breach of trust. That's the very important, breach of trust. What is breach of trust? Breach of trust means breach of duty as per definition given in section 3 of the Trusts Ordinance. A breach of any duty imposed on a trustee by any law is known as breach of trust. One of the duties specified in section 11, just now we have discussed also, is to obey the directions of the author of the trust given at the time of its creation. Therefore, if a trustee fails to obey the direction, it amounts to the breach of trust. Breach of duty, thus it is a breach of trust. An act or omission in contravention of directions of the author of the trust or duty specified in the trust ordinance or regulation made under section 115A of the trust ordinance results in breach of trust. When a trustee commits a breach of trust, section 23 states in general terms that the trustee has to make good the loss resulting because of such breach to the trust property as well as to the beneficiary. When the beneficiary himself is privy to such breach and has contributed to such breach of trust by inducing the trustee by his own fraud to commit the breach of trust, or when even if not privy to such breach by fraud or undue influence, as after breach is committed by the trustee has waived such breach with the full knowledge of facts of the breach and his rights against the trustee. Trustees in both cases is exonerated on the principles of equitable estoppel because it is an elementary rule of estoppel that no man can take advantage of his own fraud. When you read this section 23, when a trustee commits a breach of trust, he is liable to make good the loss. That's one thing, that's a general rule. But if the beneficiary induces such breach by fraud, or sometimes the beneficiary as a person who is competent to contract without any duress or any undue influence, with the full knowledge of the actions or the breach, at the same time full knowledge of his rights against the trustee, acknowledge it or accept the breach, then there is no liability on the trustees. If the trustee commits a breach of trust, he is not liable to pay the interest except in the following cases. That simply, when you say subsection 2, these are the circumstances where trustee must pay interest. The first place, where he has actually received interest. B, breach consists in unreasonable delay in paying a trust money. C, the trustee ought to have received but not received actually. D, he may fairly presume to have received, but we don't know whether whether the trustee received or not, but fairly presumed to have received the interest. And the breach consists in failure to invest trust money. And finally, paragraph F, the breach consists in the employment of trust property. When you see the subsection 3, that's very important. The trustee is liable in a case A, that is, he has actually received the interest, then he must pay such interest, whatever he received. But in the cases B, paragraph B, C, D, B, C, D in the sense, unreasonable delay, ought to have received, and fairly presumed to have received. In those circumstances, he has to pay the interest in the simple interest at the rate of 6%. These are the provisions made in section 23. That's why we have seen that the breach is primarily and essentially a wrong to the beneficiary, and if he has chosen on his free will to rectify it with the full knowledge of his own rights, he cannot thereafter be heard to complain about the wrong. So primarily, in the case of breach of trust, trustee is liable to make good the loss which a trust property or beneficiary has sustained. The trustee in such cases cannot take a plea that he has taken competent legal advice. However, before any person can be made liable for the breach of trust, he has to be first ascertain the position of the person as that of a trustee, because that person must be a trustee, otherwise you can't find a case against any person. Then we will see the case Target Holding Limited. In that case, the basic rule, in that case it was stated that the basic rule on the personal liability of a trustee is that he must restore or pay to the trust property either the assets which has been lost to the property by reason of breach of trust, or failure to account properly for the trust fund, or compensation for such loss. These principles equally apply where the commercial trustee is also involved. Beneficiary's claim against the trustee may be based on the statutory duty of care. Duty of care you would have studied in your law of tort also. Where the protector is not acting in a professional capacity, it is unlikely that he would owe an equitable duty of skills and care, as he would not have taken it on himself to assume responsibility for the beneficiary's interest. The conduct in the nature of contributory negligence by the claimant is no defense at all, but in certain countries it is accepted. Then we will move to other slide, next one. Right, this is British American Elevator Company Limited. In that case, the Privy Council has held that where the banker knowingly makes itself a party to misappropriation of trust fund, the banker himself knowingly makes a party to misappropriation of trust fund, it is liable to refund the amount. And the action against bank cannot be treated as one for damages, but is one for accounts for breach of trust. If If a trustee wrongfully appropriates a trust property and fails to utilize it in redeeming the beneficiary's property as directed by the author of the trust, the beneficiary has a right to be indemnified by him. It is no answer to a charge of breach of trust that trustee acted under competent legal advice. We have seen earlier also, the trustee cannot say that he has acted under competent legal advice. Then we will see these Mulholland's will trust case. It's a very interesting case. In this case, by a lease in 1936, the testator demised to the bank a certain property for the term of 21 years. The lease provided that the bank should have the option to purchase the demised premises subject to two conditions, namely, the first one, that the option should not be exercised during the life of the testator without his consent, and second one, that if the testator should die during the term created by the lease, the bank should have the option to purchase for 2,500 sterling pound. By his will, the testator appointed the bank as one of the executor trustees. Earlier there's a contract, then thereafter trustee on his death. On the death of the testator, bank exercised its option to purchase a property which was conveyed to the executor. In an action to set aside the conveyance on the ground that the bank being trustee was precluded from exercising option. But the court rejected the contention and said that the principle which emerges from that case is that the existence of fiduciary relationship creates an inability in the trustees to contract in regard to the trust property. The case does not touch the position arising where the contract in question had been brought into existence before fiduciary relationship. In such a case, trustee is not precluded by the subsequent fiduciary relationship from asserting his right under pre-existing contract. Then simply we can say the fiduciary relationship started later, contract entered into earlier. Therefore, the contract he was there to comply with. Like other case, Albert case here, that's Indian case 1959. In that case, the court held that this is in relation to the directors of the company. Generally, directors of the companies are the trustees. But here what happened, we'll see. The directors are trustees in a very limited sense. Not for each and everything. They are liable as trustees for the breach of trust if they have misapplied the funds or committed breach of bylaws. Their position differs considerably from ordinary trustees, and it is futile to apply the entire law of trust and the whole body of rule enunciated by the Court of Equity defining the rights and liabilities of the trustees to determine the rights and liabilities of a director. The conduct of directors is to be measured with reference to the characters of undertaking which they are appointed to manage and conduct. In the case of an ordinary commercial company, a director does not commit a breach of trust when he, in a usual course of business, sells or purchases goods from another company in which the director had interest. He is only liable for the breach of trust when he misapplies the fund or misappropriates any assets. Then there's a limited sense that the directors are trustees, not in a general sense. Therefore, we can't apply all the equitable principles and rights and liabilities of the trustees to the directors of a company. Further, we will see several breaches of trust. Where there have been several breaches of trust in respect of assets, namely conversion of an authorized investment to the unauthorized one, and subsequently to change over to another form of securities, there took place several breaches. But the trustees would be liable only for the net loss arising from series or chain of transactions in respect of original asset. In the case of breach of trust, not only the trustee but also his representative will be liable to make good the loss arising from breach of trust. It is also that the personal representative or a trustee will be liable to make good the loss for the breach of trust of the trustees, even if he had no notice of breach of trust by deceased trustee and had paid away all his assets. So the legal representatives of the trustees cannot take the plea that they could not pay securities trust the amount which the testator ought to have paid. The legal representative of the trustee shall be liable to make the good loss for the breach of trust of the deceased trustee. Even the legal representative of the deceased trustee, being co-trustee, being also answerable for the breach of trust. The liabilities of the trustees committing a breach of trust is joint and several. Therefore, beneficiary is entitled to recover from all trustees till he gets his full claim satisfied. But when the breach of trust is by one of the co-trustees and the beneficiaries elects to take action against that co-trustee, he cannot subsequently make other co-trustees liable. The liability of trustees, though joint and several, but proceedings may be taken against each of them separately. A banker with whom the trust fund has been invested and who has notice of the trust adjust the personal loan of the trustees from the account of trust fund, in such a case, the bank also has the liability to make good the amount so adjusted into the trust estate. The banker helps, here what we are seeing here, bank helps to adjust the personal loan from the trust property. In that case, bank also liable. Where the trustee who is also a beneficiary under trust commits breach of trust. And the beneficiary, trustee also the beneficiary. Where the trustee who is also beneficiary under trust commits a breach of trust, the co-beneficiaries are entitled to charge on the interest of the trustee beneficiary for the loss that may arise as a result of breach of trust. It is only the beneficiary or the trustee who has interest in trust property that can maintain a suit for breach of trust. A person has no locus standi, having no interest in the trust property, he cannot maintain such suit. Finally, in relation to the exceptions, the beneficiary may lose his right against the trustee for the breach of trust by his consent or concurrence or subsequent confirmation or release or mere acknowledgement. But at that time, the beneficiary must be fully conscious about the circumstances affecting his right. This applies to the beneficiary who are sui juris, who are adult, sui juris means adult, and so any concurrence, acquiescence or release by beneficiary who is not sui juris is hardly effective. Likewise, any consent or release obtained by undue influence will not avail a trustee. If the consent is relied upon, it must be free. Likewise, any consent or release obtained by undue influence or fraud or whatever will not avail to trustee. If the consent is relied upon, it must be free. The question of consent, etc., is a question of fact and may be implied by conduct. As for acquiescence, Campbell LC said that although the rule be that onus lies on the parties relying on acquiescence to prove the facts from which the consent of the security trust is to be inferred. It is easy to conceive the cases in which, from great lapse of time, such facts might or ought to be presumed. Then the defense of trustees against the action of breach of trust. The defense of the trustees are generally, as we have seen, concurrence, acquiescence, release and confirmation by beneficiary. Concurrence by beneficiary, acquiescence by beneficiary, release by beneficiary or confirmation by beneficiary. If a beneficiary does not suffer any legal incapacity such as minor or lunatic, etc., concurs in a breach of trust, he is stopped from proceedings against the trustee for the consequence of the act, whether or not he derives benefit by breach. A beneficiary may not conquer at the time of breach, but he is debarred from getting any relief by subsequent acquiescence in the breach of trust by reason of inoperative delay. A beneficiary may preclude himself from his remedy against the trustee by executing formal release of breach of trust or by giving validity to the transaction by express confirmation to the breach of trust. requirement of release or confirmation or whatever are that following condition must be satisfied. To consent the beneficiary, or to release something, to confirm something, the beneficiary must have certain qualification. These are the conditions must be full satisfied. The beneficiary must be of full age and capacity. Second thing is beneficiary must have requisite degree of knowledge. And finally, release must not be wrung from the beneficiaries by distress. In considering the liabilities of trustees relating to breach of trust, distinction should be made between the innocent breach of trust and fraudulent breach of trust. In the Selvakkunapalan case, 1840, a very long time ago, it was held that the innocent breach may arise in case the trustee neglects to invest or make improper investment, or when he fails to realize security which the settlor has directed him to do so in terms of the deed of trust. In such cases of innocent breach of trust, the measure of damage shall be actual loss sustained to the trust fund by act or omission of the trustee. However, when the breach of trust consisted of converting authorized securities to unauthorized investment, beneficiary may either seek for replacement of the stock, and if that is not possible because stock has had depreciated in value, then the amount originally realized by unauthorized sale of stock shall be the measure of damages. Then what is known as fraudulent breach of trust. Where the breach of trust is fraudulent, such as mixing up trust funds with his private funds by trustee and using the same for his own purpose, then the measure of damages which the beneficiary is entitled to claim on the account of profit that the trustee has made by using the trust fund for his personal gain, or the interest at the 6%. So his option is either to account for profit or interest of 6%. Even if the trustee is guilty of breach of trust, he is not liable for interest, simple or compound, except in the circumstances stated in the paragraph A to F that we have seen earlier of section 23. The illustration appended to the section furnishes instances of several aspects under which a trustee renders himself liable for the breach of trust, and also the circumstances under which trustee shall be liable for the interest as well. Illustration A, C, D, E, F, G and H indicate that the circumstances in which the trustee is liable not only the loss but also for the interest, either simple or compound. You know the simple interest and compound interest when you would have studied in your O-level maths. The trustee who have failed in their duty to convert the trust property at the proper time, he would be liable for the loss occasioned thereby together with the interest. Together with the interest. These are the main points that we must see in this section 23 of the Trust Ordinance. Now we will move to other slide here, that is in relation to section 24. Section 24, the trustee who is liable for the loss occasioned by breach of trust in respect of one portion of the trust property cannot set off against his liability a gain which accrued to another portion of the trust property through another and distinct breach of trust. The principle of this rule is that any gain made out of the trust property belonging to the beneficiaries, and while a loss incurred by a breach of trust by trustee must be made good by the trustee, and the trustee cannot set off a gain in one transaction against the loss made in another unauthorized transaction of trustees. This is a true application of the rule, heads I win, tails you lose. When a trustee commits distinct breach of trust, he is not entitled to set off the gain in one against the loss to another. The gain that has accrued by breach of trust in one transaction will inure to the estate but loss in other transaction, if distinct, will fall on the trustee. Section 24 has embodied the principles of equity, that a trustee liable for the loss occasioned by breach of trust in respect of one portion of the trust property cannot set off against his liability the profit or gain which has accrued to another portion of the trust property, though through another distinct transaction. Just as an example here, when a widow who was the executor for trustees and also tenant for life under a trust of will, postponed the sale of shares which constitute a breach of trust. She was not held to be entitled to set off the loss in respect of some shares against the gain in respect of sale of some other shares. So it is clear that profit from one breach of trust cannot be set off against the loss from another. What happened in this case, Bartlett case? In this case, the courts allowed the bank to set off the loss, observing that general rule as stated in all the textbooks with some reservation is that where the trustee is liable in respect of distinct breaches of trust, one of which has resulted in a loss and other in a gain. He is not entitled to set off the gain against loss unless they arise in the same transaction. Therefore, distinct breach in the sense, if the loss or breach occurs in both in a same transaction, one and same transaction, then one point the trustee gains something, in other point he loses something, then it is possible to set off. Then we will move to other slide here, next one, 25, where a trustee succeeds another, he is not as such liable for the act or default of his predecessor. Whatever done the former man, no problem at all. The new trustee is not liable or the act whatever done by predecessor. The new trustee will not be liable for the default of his predecessor in the office only if he is not otherwise liable. New trustee generally is not liable for the default or whatever mistake done by a predecessor. A new trustee, though not liable for the default of his predecessor in office, may render himself liable by his own act of commission or omission in not duly repairing the breach of trust committed by his predecessor that he himself became aware of and of which he would be possible to him to remedy. Then he is liable. Now, there's two things we must consider. The default done by predecessor. At the same time, there was a time within which the new trustee would have repaired that breach of trust, or he would have found some other alternative to remedy such things. In those cases, he became aware of that, but he didn't take any action. In that case, the new trustee is liable. The first duty of the new trustee on the taking office is to inform himself of the state of the trust property and to make proper inquiries in that behalf. If as a result of inquiry it is found that some steps are necessary, he must take the same. If the property is lost to the trust property, he must investigate the possibility of its recovery in whole or part. If necessary, he must seek direction of the court for steps for recovery. If, however, trust money has not been properly invested, he must call in the investments. However, it is not incumbent upon him to scrutinize the existing authorized securities relating to their title or value. Thus, if a new trustee make necessary inquiries and take proper action, he would not be liable for the breach of trust of his predecessor. On his failure to do so, he would be render himself liable for any resulting loss due to own inaction. Moreover, if succeeding trustee could not take any action to save the property from consequences of breach of trust committed by his predecessor, his neglect to do so, it might, in given circumstances, constitute a breach of trust by him. Then he will be liable. Then we will move to section 26. 20 is subject to the provisions of 13 and 15. The trustee is not as such liable to breach of trust committed by co-trustee, another trustee. According to the general rule, a co-trustee is not liable for the breach of trust committed by another trustee, another co-trustee. It is only in exceptional cases as specified in the section in the paragraph A to C of the proviso to subsection 1 of section 26, a co-trustee may be liable. The general rule is subject to 13 and 15, section 13 and section 15 of the trust ordinance. Section 13 enjoin upon each trustee to protect the title to the trust property. And section 15, as we have studied, enjoin upon each trustee to deal with the trust property as carefully as a man of ordinary prudence would deal with such property if it were his own. But in the absence of contract to the contrary, a trustee so dealing with the property is not responsible for loss, destruction or deterioration of trust property. Then we will see, we will move to other. This is a exception given here. Then we will see subsection 2 and Smith case. In Smith case, the deed authorized the trustees to invest in or upon such stocks, funds, securities as they shall think fit. That's very important. As they shall think fit. The trustees invested 3,000 sterling pound upon the debentures. By so investing the funds in the debentures, one of the trustees received a secret commission of 3,000 sterling pound. The co-trustees has assented to the investment, thinking that it would benefit the trust property, but the debentures had never commanded per value, and at the time of filing action they were of little or no market value. It was held that the words "as they shall think fit" meant as they shall honestly think fit, that the amount received by trustee as commission was bribe, and the such trustee must make good the loss occasioned by investment of 3,000 sterling pounds as for the conquering trustee, that since he had acted bona fide, therefore did honestly think fit, he would not be liable. Then another case here, Wilkins versus Cox. What happened in this case? Lord Westbury formulated 3 exceptions to the general rule, which has been enumerated 3 paragraph to section 26 that we have seen. Therefore, I don't need to read that section again. If a trustee is negligent in not inquiring as to the due application of trust property, trust fund or property while in the hands of co-trustees, the trustee shall be liable for the consequent loss. The trustee thus allowing the co-trustee to retain the rent collected by him for a long time, and ultimately they are lost, then the co-trustee would be liable. When the trustee, after becoming aware of threatened breach of trust by co-trustee, takes no action to prevent it, he is liable on the ground of connivance with the co-trustees for committing a breach of trust. It is settled law that the trustee would be liable for the money received by him for the trust fund. However, if he joins in a receipt for the trust property but has not received money himself, and the co-trustee received the same, he would not be liable or responsible for said money when he did not receive the same, but only joined in a receipt for conformity. Then we will move to other slide here, that is section 27. Section 27 provides for several liabilities of co-trustees when they jointly commits breach of trust, or where one of them by his neglect enables other to commit breach of trust. The second paragraph provides for the contribution as between the co-trustees. But as regards the contribution, a distinct has been drawn between the cases when a trustee is less guilty than others and when they are equally guilty. In a case when a trustee is less guilty than others and has had no refund the loss, the former may compel the latter or his legal representative to the extent of the assets he has received to make good the loss. But if all of them are equally guilty and one or more trustee has refunded the loss, he or they may compel others to contribute. However, in subsection 2 of section 27, just we will, 2, the exception to this rule of contribution has been enunciated that is when the trustee has been guilty of fraud. He cannot compel the other co-trustees to contribute by filing a suit for contribution. This section embodies the equitable rule that as between themselves the trustees are equally liable, and if one of them is compelled to pay more than his fair share, he has a right of contribution from his co-trustees. There is no argument for any trustees to say that he was merely passive trustee. Passive trustee by doing nothing may neglect his duty more than a trustee who acts honestly though erroneously. In the case of breach, the beneficiary can sue all or any one of the trustees and start execution against all or any of them as he chooses. Now we will see section 28. Section 28 confers protection on trustees who bona fide pays or delivers the trust property to the person who would have been prima facie entitled to the beneficial interest in the trust under instrument of trust. But since the property becomes invested to another person for which trustee had no notice, he is not liable for the property so vested. This rule is based on the general rule that the person on whom the interest of the beneficiary has devolved must put the trustee to notice of his right. And in default of such notice, trustee would be justified in paying or delivering the trust property to the beneficiary as per terms of instrument of trust. This situation arises when the interest in the property is claimed derivatively by assignment or transfer, which the trustee could not be expected to be aware of and of which trustee had no notice either express or implied, and the trustee would be protected in respect of payment or delivery made by him to the person entitled to the benefit of the trust under the instrument of trust. The vesting of such property to another may be by operation of law or by act of parties. Therefore, a trustee makes a payment bona fide to the person originally entitled to the beneficial interest of the property. Trustee shall not be liable to pay again to the person who derives title by way of assignment on the basis of derivative title holder. Now we will move to section 29. 29, just you can read and understand, but I explained to you that also. When a beneficiary's interest in the trust is forfeited and awarded to the government by any adjudication made by the court of law, the trustee shall not put such property for the beneficial enjoyment of beneficiary as per the terms of instrument of trust. The trustee has to administer it in such manner as the government may direct in that behalf. So whether or as to what extent the beneficiary would enjoy such property, so forfeited or awarded to the government by legal adjudication would be under dictate of the government on whom such property forfeited. Then we will move to section 30. Section 30 codifies the rule of equity that the trustee is only answerable for the trust assets actually received by him, and it consequently indemnifies him from all liabilities as regards the assets received by co-trustees, as well as from liabilities for the acts of any banker or broker or any other person in whose hand trust property may be placed in the normal course of business, nor for insufficiency or deficiency of stock or funds or securities, nor otherwise for involuntary losses. The entrustment of the trust property to the banker, broker, like a person is in the persons, is a matter of common practice in the normal course of business, and if such employment is reasonably necessary, then the trustee cannot be held liable for any loss occurring while the trust fund is in the custody of such banker, broker, or any other person. Section 20 relating to indemnity of trustees is subject to, firstly, the provisions of section 23, which make the trustee liable for the loss on the account of breach of trust by him, and section 26 of the trust ordinance, which exempts the trustee from liability for the loss when the loss occurs to the trust estate due to the default or breach of trust of co-trustee. Thus, if trustees fails to take proper care and funds are lost by misappropriation or improper investment by co-trustee, section 26 does not exempt a trustee from such liability for the loss which occurred due to the breach of trust committed by a co-trustee. When the trustee is guilty of willful default or gross misconduct or gross violation of duty, he cannot escape liability. Indemnity of section 30 of the Trusts Ordinance cannot exonerate the trustee even if the trust fund was not in his possession but in the hands of other co-trustees, or in other hands like a banker, broker, and other persons. If he acts bona fide and takes proper care, the trustee cannot be held guilty of misconduct of co-trustees, etc., in whose hand the trust fund may be at any particular time. Now we will move to the final section, that's section 31. This is a very interesting section. If it appears to the court that the trustee is or may be personally liable for the breach of trust, whether the transaction alleged to be breach of trust occurred before or after commencement of this ordinance, and the trustee acted honestly and reasonably, and also ought to be excused for the breach of trust and for the omitting to obtain the directions of the court in the matter in which he has committed breach, then the court may relieve the trustees partly or wholly from his personal liability. Now what is the idea of this one? If the trustee if the trustee did something honestly, reasonably, then court of the view that he must be excused for the breach and also must be excused for omitting to obtain the directions of the court, then court has the power to relieve the trustee from the personal liability. That is the end of liabilities of the trustees. Now we have seen the duties of the trustees. Now we have completed liabilities of the trustees. Thank you.